Today we're going to be talking about the Warren Court and how it impacted America. So let's just start with a little bit of historical context. This is in the 1960s that we're talking about. Most of these are in the 1960s. And so the country is on a liberal trend. We see the civil rights movement, we see the women's rights movement, we see an American Indian movement. People are pushing for rights. And so the cases that we're going to be looking at today deal with the rights of people accused of crimes. And so the Warren Court is known for being this liberal court, and some people who don't like that call this an activist court. And usually that's a derogatory statement by the people on the right against people on the court acting in a leftist way. Okay, so I started off in our handout here just kind of reviewing what it means to be due process. And in general, due process means fair treatment by the government. And generally speaking, due process can be found in the 4th, 5th, and 6th Amendments to the Constitution. So if you look at the exact wording of the 4th Amendment, and I asked you some specific questions, exactly what is protected: persons, houses, papers, and effects. That's what's protected against unreasonable searches and seizures. And so what makes it reasonable is that the government must have a warrant based upon probable cause, and that means it's likely that you're connected in some way to the crime, and it must specifically describe the person or things to be searched and seized. And I like to examine this 4th Amendment in a little bit of detail only because it does not specifically use the word privacy. It's kind of implied here, but it's not written here. And when we talk about Roe versus Wade and women's right to control their own bodies, one of the things that people talk about is this inherent right to privacy that we have, and they point to the 4th Amendment. And it's not specifically written in the 4th Amendment, which is why you see people who are opposed to abortion rights arguing that privacy doesn't really exist. So that's an argument that's out there. It's kind of related to other issues, but you should be aware of that. Okay, going on to the 5th Amendment, where this lists all of our due process rights. You can't be charged for the same crime twice. You have a right to remain silent. You must be given due process before the government takes away your life, liberty, or property, and the government can't take away property without paying fair market value for it. So if the government wants your house because they're planning to build a road, they absolutely have the right to take your house. You can't argue, but you can argue about the exact amount of money they'll pay you for it. And that's called eminent domain. Okay, moving on to the 6th Amendment. You have a list of our due process rights here: speedy and public trial, impartial jury. You need to be told of the charges against you, to be able to confront those people who are accusing you. That's called the Confrontation Clause. You have the right to force witnesses to show up on your behalf. Let's say they're scared to show up. You can force them to show up with a subpoena. And you have the right to an attorney. So all of this is part of due process. And then we have some really influential cases in the 1960s. And the first one that I put on our handout is Mapp versus Ohio. And just to give you a little bit of background, there was a case in 1919 called Weeks against United States, where the Supreme Court created the exclusionary rule for federal cases. And the exclusionary rule means that if the federal government got evidence against you in a way that violated your rights, like it didn't have a warrant to search your home, then that evidence can't be used at trial. So that's what the exclusionary rule is. It still exists today. But between 1919 and this case in 1961, this rule only applied to the federal courts. So if the local police violated your rights and got evidence in violation of your rights without a warrant, they could still use that evidence. So it was kind of an unfair standard. So this case changed that. All right, so let's go through our questions. What did the exclusionary evidence exclude from trial? Well, they excluded illegally obtained evidence, and it can't be used at a trial. Why? Because they don't want to reward the police for violating your rights. And what good is a constitutional right if it can be violated without any consequence? Okay, how did Justice Black's reasoning differ? Well, he said it's not just the Fourth Amendment protection against unreasonable searches that demands illegally obtained evidence be excluded from trial, but the Fourth Amendment coupled with the Fifth Amendment's ban on forced self-incrimination that makes it so. So he kind of put these two amendments together to help support the exclusionary rule. And Justice Harlan was concerned about the states' rights to follow the exclusionary rule as they see fit. Okay, so he was somebody who didn't necessarily want to extend the exclusionary rule, and if you are marketing yourself as a law and order type, you might say that this rule makes it more difficult for the police. Because now if they kind of bend the rules, there's a consequence. They can't use that evidence. So it certainly does make it more difficult for the police, and that would be a criticism of this case. Okay, how does this expand the meaning of due process? Well, the people who support this idea say there's now a punishment for the police if they obtain evidence in violation of a person's due process rights. Okay, our next case is the Miranda case in 1964. I'm sure you've all heard the Miranda rights being read in movies and on TV shows. And the decision was that the police must inform suspects of their right to remain silent at the time of arrest. Okay, that's why they do that, because of this case. Before this case, the police did not have to do that. Justice Harlan felt that the new rules would impair law enforcement, because they said once you inform the person that they have a right to remain silent, then anything they say will be used against them. It's going to end the interrogation, and the police will be hampered from obtaining confessions. Okay, and how does this case expand the meaning of due process? Well, now you have a new due process right. It's not in the Constitution. It comes from this case that the police have to inform you of your rights at the time of arrest. Just want to look at one thing. Okay, so this Justice Harlan we see is a conservative. He was concerned about states' rights, and now he's criticizing the Miranda case, saying that it's going to be more difficult for the police. So you can see some of his logic is consistent. Okay, the Gideon versus Wainwright case. This guy, Clarence Gideon, broke into a pool hall where they play pool, and he stole some money, and he didn't have enough money to afford a lawyer, so he complained. And the majority opinion said that the state government must provide an attorney to indigent or poor defendants in all cases to guarantee a fair trial. So that was his goal, the goal of the majority decision, I should say. Justice Clark agreed with the decision that all people should have an attorney, but for a different reason. He said that whatever the punishment is shouldn't determine the fairness of the trial. All defendants on trial for capital cases would be fair trials because they would get they would get a lawyer, but defendants on trial for robbery would not have a fair trial because they would not be able to afford an attorney. That doesn't make sense. So he's looking for equity here. Okay, now I asked you to make some generalizations about these cases, and then along with your homework, which I'm not really sure what homework I assigned you, so I just kind of filled this in, and I'll explain that. All right, so due process. Well, we've now extended the meaning of due process. It now means illegally obtained evidence can't be used at the trial. It means suspects must be informed of their rights at the time of arrest, and the poor must be provided with an attorney. So these new rules make the system of justice more fair for the poor and the uneducated. So we don't want to have two different systems of justice, one for the wealthy and one for the poor. That would really create unfairness in our society. And so the goal of these cases is to just try to create a truly fair system. And then I had a box here for free speech and press. And as I mentioned, I'm not really sure what I had assigned to you for that, but I know that I was thinking about the Tinker versus Des Moines School case. And that's the one where the students were protesting against the Vietnam War, and they wore black armbands to show their protest about it. And this is when the war was going on. And a lot of the students, were forced to sign up, and they might have been going to fight. They might have had siblings going to fight. And it was a very heated issue, so the school wanted to ban the armbands. But the Supreme Court said no, because the students were allowed to wear the armbands because it was a sign of symbolic political speech. And there's a really famous line from this case that free speech does not stop at the schoolhouse gate. Maybe we'll write that in there. That was a mess. Let's see what happened. A couple of typos in there, I think. Okay. No, not okay. All right. Another case that I know we did discuss was the New York Times versus U.S. case that the government cannot restrain the press from printing the Pentagon Papers because it was not a true threat to national security. So the Supreme Court limited the power of the executive branch to stop the press. So in both of these cases, we see the government being limited and individuals' rights being protected. And so that's a theme that we see in all of these cases that we looked at today. So the goal of the Warren Court was to reinforce the meaning of justice, support or refute. Okay, I think that mostly we could say that it supports because the system of justice was created to be fair, or extended to be fair, so that people who were accused of crimes would really be able to defend themselves. It limits the power of government, and the whole goal was to create a system where people could adequately defend themselves. If you were more of a law and order type, you could try to refute this a little bit the way Justice Harlan did. Let's let the states make up their minds about how much they want to enforce the exclusionary rule, or let's not tie the hands of the police by forcing them to inform all of the suspects of their rights at the time of arrest. It's not the police's obligation to inform them. So you could likely argue both ways, but I think the argument for support is a little bit better on this one. All right, everybody, have a great day. Bye.